So good afternoon, everybody. Before I start my presentation, I would like to say thank you for inviting me. I'm very happy to be here today with you, and I'm also very honored to be invited. Let me first introduce myself. My name is IRISZ. I'm coming from Hungary. I work as an in-house legal counsel at Central European University. When I was invited to speak about the GDPR, I was wondering what topic specifically to choose, which would be of most interest for you. And given that you have already discussed some of the basic principles of GDPR in Bucharest, that's what I saw, I asked for some questions, to collect some questions from you that you are very much interested in. And I saw that there were questions focusing on research mainly, so how GDPR is connected to research, what are the most important aspects. Also, there were some questions about open access and also about the data management plan. So based on these questions, I put together my presentation. There will be quite a few slides stuffed with a lot of information. Please do not bother about those. I will try to summarize and just share with you the most important information from those slides. So my presentation will be based on four main parts. I will be talking just very briefly about the basic principles of the GDPR, just to be on the same side. And then I will continue with focusing on research, so how GDPR addresses research, what are the most important requirements under the GDPR when we are talking about research. Then I will continue with another topic, which is about open access and open the data, and also about drafting a data management plan, which is a requirement under Horizon 2020. And finally, I would like to conclude by sharing with you some of CEU's best practices related to implementing the GDPR within our university. So what we did, how we started, and then where we are now with the implementation. So to start, I would like to share with you just very basic information about the GDPR. So as you all know, we have a new general data protection regulation that has entered into force in May this year. And some say that it has basically shaped the new landscape considering data protection within EU. Some others say that most of these rules have already existed. However, why there is such a big focus on this is that the sanctions are very high. So basically, the authorities are really looking very closely on how we implement these new rules. So probably just a few words about what is new. So compared to the EU directive, what is probably the most important thing is that some general principles have been introduced. We call those the 6 GDPR principles. I will have a separate slide on those. So these principles have been strengthened, and these principles basically constitute the core of data protection now within Europe. Also, what is very important and probably new is that a new approach is required from institutions under the GDPR, which I call a so-called active approach. So institutions should not just sit and be passive, but really try to actively demonstrate how they comply with the GDPR, how they try to protect the privacy of personal data. Also, what's very important, as I mentioned already, new sanctions have been introduced. So there is a great focus on enforcement by the data protection authorities. What is also significant under the GDPR is that the rights of the data subjects have been strengthened. So basically, they have quite a few rights under the GDPR related to their personal data. They can ask their data to be erased, deleted. After a while, they can ask a lot of information about how their personal data is treated, and so on. I would not go into the details of this. And finally, the accountability approach is something I have already mentioned to you. This is connected to the so-called active approach that I call, that is expected from the institutions. so that we as institutions should be able to prove what we did, so that we have correct policies in place about protecting personal data and so on. So we have to be transparent basically towards the data subjects. Now, just a summary of these 6 basic GDPR principles based on which our data management should be basically built on. So these 6 principles are the following. The one is about lawfulness, fairness, and transparency. Now, very briefly, what does this mean? This basically requires institutions, or in general, all those who are acting as data processors or data managers, to be transparent, so to be able to show to the data subjects what will happen to their personal data. Fairness is very closely linked to this. It basically means that once you have communicated to the data subject what will happen to their personal data, you have to stick to that. So you have to really follow that, what you earlier told to the data subject. And lawfulness basically means that you have to follow the legal requirements of data management. Now, the second basic principle that you always have to keep in mind is the purpose limitation. That is, to put it very simply, it means that you always have to find a purpose for what you are collecting personal data, and you should only collect personal data for that very specific purpose. Data minimization is another principle that encourages us to collect only those data which are absolutely necessary for reaching a specific purpose and nothing more. So not to generate excess personal data. Accuracy, I think that speaks for itself. It's about keeping personal data accurate, so that once you have personal data in your database, so that you ensure that those personal data are accurate and always up to date. The storage limitation is another principle, all linked. These principles, as you can see, are somehow all linked to each other. It's a requirement to store personal data only as long as it is absolutely necessary. So only for a period until you need that personal data for your original purpose that you have determined at the very beginning. Once that purpose has been reached, you should get rid of all personal data, by deletion, or you should anonymize those data and so on. And finally, integrity and confidentiality. It's a very general principle about protecting the confidential nature of personal data. In the next few slides, I would like to tell you, as I mentioned, or to focus on the research aspects of GDPR. So what are those most important requirements that the GDPR determined for researchers in general? So what is new under the GDPR in general when we are talking about research? Probably the most important thing that I would like to highlight, and around these things I basically built up the several slides that you will see. It's the DPIA. The DPIA is the Data Protection Impact Assessment, which is basically a new obligation introduced by the GDPR. Now, what is this? To put it very simply, this is a test that should be done by all those who are dealing with personal data before they actually start collecting personal data. Now, this test, you will have several slides on this, but just at the beginning to tell you now, the reason of this test is to have, let's say, a test on what impacts the collection of personal data during a research project, for example, will have. So this requirement is again somehow linked to the two new principles or approaches of the GDPR, which is the accountability and also the data protection by design. So the aim of this test is basically to show data subject transparency again. or as a first step to see what impacts your research and your collection of personal data will have on their rights and freedoms by collecting their personal data. And also, as I mentioned, to be transparent so that you can show to the data subject that you have considered their basic rights before you started to collect their personal data. Although this is a new thing, the DPIA introduced by the GDPR as an obligation, but as a concept it's not new. Because some institutions have already been carrying out this kind of test as a part of their best practice. So privacy impact assessments have been used by the institutions for years already. But what's new under the GDPR, as I mentioned, that now this became an obligation in specific cases. So not always, but the GDPR mentions those cases when you have an obligation to carry out a DPIA test before you start collecting personal data and before you do your research that is linked to personal data. This slide is just, let's say, a general slide about how you should treat personal data during your research. This has been taken from our internal data protection policy. Of course, it is more detailed. I just tried to take out some of the most important aspects. And the aim of this summary is for our researchers just to give them a hint of where they should start when they start to collect personal data. So what is probably the most important thing is that before they start research and before they start, researchers dealing with personal data, they should always keep in mind these 6 basic principles of the GDPR, which really represents the basic rules when you are dealing with personal data. Also, what we always recommend to our researchers is to carry out the DPIA. I'm not saying to carry out the test itself, but at least to assess whether there is a need for a DPIA. And based on that, then to decide whether they will do the test, yes or no. Also, what I find very important is to communicate with the data subjects. I think this really adds to transparency. Because if you are able to tell to data subjects what will happen to their personal data, they may even contribute by saying, whether they agree with this. Then later on during the procedure, so during your research, you will have a better working together with the data subjects. I think this is really a helpful tool for that. So probably even before research, as I already mentioned, so before researchers start to collect personal data, it is very important to inform. So I think this is really a key word. So to inform the data subjects about what will happen. This can be formalized in a way of a privacy notice. This is also a requirement of the GDPR. You have all, I hope, come across to this. So to set up a privacy notice, that is a formalized document in which you really focus on some basic concepts of collecting personal data, like setting up a purpose, so why you are collecting those personal data, what is the legal basis of collecting those personal data, what types of personal data exactly you are going to ask from the data subject, how long you are going to store it, what will happen with those data after the project is over, and so on. So the privacy notice is one formalized way of informing the data subject, so what will happen with their personal data. And this should always be set up in advance, so before you actually start collecting the personal data. What is also very important that we like to tell to our researchers not to generate excess personal data. So this is also linked to one of the 6 GDPR principles, the data minimization principle that I already mentioned. So only focus on what you really need for your research and collect only that amount of personal data. And this is also helpful for the researcher because, the less personal data you have, basically, the less risk you have, because if you have access personal data, that obviously puts you to a higher risk. Also, what's very important regarding IT security that we emphasize always, so that before they start collecting personal data, they really need to make sure that you know, all the technical background is really the one that can really serve confidentiality, so that you have ways to encrypt personal data and so on. Now, after all this, when you start research and during research, it's very important that once you, let's say, have a consent from the data subject, you manage to inform the data subject. After that, you keep this, let's say, obligation or this approach ongoing. So this is not just at the very beginning of the research, but continuously. What do I mean by this? Maybe when you start your research, in the meantime, some things may change. You may need to change the purpose, so you need to collect additional personal data and so on, which is absolutely fine. But in that case, what's really important is that you, again, you know, keep the relationship with the data subject and keep them informed continuously. And for example, you should reshape your privacy notice accordingly. So if something changes, then you should also change your privacy notice. And of course, finally, if there are any questions at all the time, you should always consult your data protection officer and, you know, keep this relationship alive with the data protection officer during your research. Now, more specifically, so what is this DPIA? So as I mentioned, this is a new obligation under the GDPR, the Data Protection Impact Assessment Test. Now, what is the purpose of such test? It's basically to analyze personal data processing. So to analyze your process, in which way, or what is the purpose. So this test basically helps you to identify identify the risks that may be associated with collecting personal data, and not just to identify, but also to, once you identify specific risk, then also to assess them, their level, whether they are high risk or low risk. Also to look at the impact such risk may have on data subjects. And finally, to try to minimize these risks, either eliminate them completely, or if they remain, at least to mitigate these risks. And if you are not, at the end of the day, if you are not able to minimize those risks, at least to try to justify why those risks will remain. So why, despite of all these risks, you still continue to collect and use those personal data. Now, this test should, as you can see on the slide, consider several risks, the compliance risk. Most importantly, the risk that should be considered is the risk that collecting of a personal data may have on the basic rights and freedoms of the data subjects. Also, there might be some other risks associated with collecting personal data. You will see that on a separate slide. Now, what I would like to focus on when we are talking about the harm or the potential risk that may be caused to a data subject by collecting their personal data is the potential harm. So here the focus is on the potential. So it's not just about the actual harm that may be caused to a data subject, but also a potential harm should be considered. And when you are making this test and trying to collect the risks and also to see the levels, as I mentioned, it's very important that you look both at the likelihood of appearance of such a risk and also how severe such a risk might be, considering a specific data subject. I will have a table summarizing this process, so how to assess the level of the risk later on one of my slides. Now, as I mentioned to you, the DPIA, so conducting a data protection impact assessment test prior to starting dealing with personal data is first a legal requirement in some cases listed in the GDPR. So this is first a legal requirement, but this is not just a legal requirement, but also a compliance tool. And I will tell you in a separate slide what do I mean by that. So as a legal requirement, I have already mentioned to you that in some cases it is obligatory to do this test. And this is also connected to the principle of accountability, where institutions in general are required to show that, that they do have best practices for protecting the confidentiality of personal data. Yes, and just a general remark here, since this is a specific obligation, again, only in specific cases, so to do this test, the GDPR introduces a sanction. So if there is an obligation to do the DPIA, and if an institution fails to meet that requirement, it can be sanctioned. And as you can see, and as you already know, the fines are quite significant. So I think complying with this obligation is extremely significant, but not just as a legal requirement, but also from compliance aspects. And why is that important when we are talking about compliance? Some may say that introducing the DPIA test as a requirement is just an additional burden on institutions, because you have to to do this test. It really requires time. There are a lot of questions to go through once you came to a conclusion. So what are the risks and how you can mitigate those? So this is, let's say, additional burden, but in my view, it's not just an additional burden, so to say, but it's also a very good tool to build a trust with the data subject, because if you can, show publicly that you really care about the confidentiality of the data subject's personal data, I think that's really something for your institution to show like as a good practice. So. Yeah, so here are a few ideas why DPIA can be a very effective compliance tool, because if your institution is really carrying out these kinds of tests, then you can really demonstrate compliance, for example. And it also helps the researcher to identify the risk. So it also helps us when we are dealing with personal data. Also, transparency is improved. Again, the institution is more transparent if they can show that we are doing this test. And they can also be some financial benefits, for example, because you can avoid later on some costs. And not mentioning the reputational damage that an institution can suffer. So all this can be prevented in a way if you use the DPIA, also in those cases where it's not an obligation, but still you do that based on your own decision, just as a compliance tool. Now, how this test is used? Probably here, what I would just mention is that the DPI should not just be, let's say, a one-time test, so at the very beginning of your research. So you should not just do this test and then at the beginning and then say, now I did this test, everything is fine, and just lay back. But just as I mentioned, this is a living process. So even during your entire research process, you should keep this alive, in a sense that if there are any changes to data processing, you should always adapt your actions or your research accordingly. Now, what are these risks that I have mentioned earlier? So what are these kinds of risks that the management of personal data can cause to individuals when we are collecting and managing their personal data? Well, first of all, I focused on potential harm, so not just actual, but any potential harm that can happen to them. And the harm, when we are talking about the risks, these are risks to the data subject's rights and so basic rights and freedoms. Also, some economic and social disadvantages may be caused if you are treating personal data in an inappropriate way. And also, The GDPR's recital also speaks about some effects that the collection of personal data may have on a society as a whole. The final two remarks on this slide I've already mentioned, so how to assess the risk, the likelihood, and how severe a risk is very important to be assessed and taken into consideration. Now, more specifically, when do we need to do a DPIA? As I mentioned, the GDPR lists those cases when researchers really have an obligation, basically, to do this test. And now the GDPR uses a very vague definition that I highlighted in blue on the slide. So there is no obligation to do a DPIA in cases where data processing is likely to result in a high risk to the rights and freedoms of the natural persons. Now, these words, likely, high risk, these are of course not defined, so you can imagine, how vague this definition is. But still, there are some explanations to how we should assess this requirement. A high risk is basically, again, when you would like to decide whether certain data management will have a high risk or potential high risk on a data subject, again, there is this test of how likely a specific risk is to occur and how severe the impact will be on a data subject's right. Again, I'm referring to that table that I will show you about, the system of how to assess the level and the likeliness of a risk. Now, more specifically, what types of processing automatically require the DPIA? So this is in the GDPR mentioning that in these three cases, so when you are doing these three cases, when you are faced with these three cases, then you definitely have to do a DPIA. The one is when you are doing a systematic profiling. In that case, before you start that, you must have this test. Also, when you are dealing with some special category of data, or when you are dealing with criminal offense data. So when you are collecting these types of data during your research, then before you start doing that, you must have this test based on the GDPR. Or there is also a third case when you are systematically monitoring publicly accessible places on a large scale. So when these three cases occur, then please remind that in these cases, before you start doing anything with personal data, always refer to the DPIA test. There are also some other examples of data processing, so very specific types of data processing, where it is not an obligation based on the GDPR, but it's a requirement to have, in this case, a DPIA. This is a UK example. Basically, a lot of information in my presentation has been taken from the ICO, which is the UK Data Protection Authority. They have really very useful information, so for you who are interested, you can really consult those pages for further information. Yeah, so this is basically the recommendation of the ICO, the UK example, for those cases where it's not an obligation to have a DPIA, but still it is very good practice to do this test. Just a few examples. For example, when you are introducing new technologies during data processing, then it is very advisable to do this test. Or denial of service. Let's say you decide not to give access to a specific service to a data subject, then again, you should do this test and to be able to prove, what the impacts of collecting their personal data would have on their rights, and then come to a conclusion why, let's say, a specific service would be denied based on these risks that may come as a result of this test. You can also see some other examples. I would not go into details. We'll see if these slides will be available or sent to you if you are interested, so you can get more information from this. But again, what I would like to point out is that even in those cases where it's not an obligation, it's always good practice to do the DPIA test before you start dealing with personal data in your research. There are other examples in Article 29 Working Parties recommendations. You can also find some other examples. Again, this is not an obligation, but these are just further examples where if you are coming across these cases, it is very advisable to do the DPIA, so this data protection impact assessment test. Some exceptions where you may not have. Yeah, sorry. Okay. Okay. Is it better now? Okay. No? Is it? No, it's okay. Okay, sorry. I will try to pay attention to this. So these are those examples where you may decide not to do a DPIA. For example, when you are let's say if you have a very clear statutory basis for data processing, so in those cases where there is a legal requirement to do data processing, in those cases you may avoid to do this test because this is a legal obligation, so you have to do it anyway. Or let's say if there was a similar case earlier, so a similar type of data processing earlier, and you did a DPIA then, and the basic environment is the same, then you may not do a DPIA test again. And also, the member states may issue certain lists for like a recommendation where you should do a DPIA or where you may avoid a DPIA. So you should also consult your National Data Protection Authority for further guidance. And now in this slide, I've tried, this is also from the ICO's website. This is, I think, a very helpful cycle to show you the process of doing this test, so the data protection impact assessment test. Just very briefly, as a first step, so how to start a DPIA, first you need to identify whether there is a need for a data protection impact assessment. And how do we identify that? There are separate slides for each of these steps in more details, but just very briefly, here you have to assess the risk, any potential risk, whether there is a risk at all, what is the nature of that risk, whether that is a high risk, a low risk, and so on. And based on that, you can decide whether to go on and complete this test. Then, once you start doing this test, the next step is to describe the data processing let's say project or the entire procedure. So to describe in details what will happen to personal data. As a third step, you may consider consultation. So you may consider consulting with, again, data subjects who are affected, and also with some other parties you will see on a separate slide. After that, once you started this assessment, you should also look at the necessity and proportionality. Now, what are these two keywords? You should also look at whether the collection of those personal data are really absolutely necessary for your project, and whether they are proportionate. So to see whether you are collecting personal data which is closely connected to your research, or whether there are any excess data that you may not need. So most probably you should get rid of those data or not collect them at all. Then as a next step, you should identify the risks that may be somehow related to collecting this personal data. And then once you have identified these risks, you should look at whether they can be eliminated or somehow mitigated, if not eliminated. Then signing off and record outcomes. This is very important. I will focus on that and try to point out several times. I will be mentioning this. because this is really the essence of the whole thing, is to record everything so that you have documentation of what you have done. And this is also a requirement or a good practice when you are looking at the GDPR as a whole. If you remember at the beginning, I mentioned to you one of the principles, which is the accountability of an institution, which is dealing with personal data, so that you have this active approach, so that you can show what you are doing with personal data. And one tool for that is for you to record everything in writing. So what you did, why you made a specific decision, you know, what to do with the personal data. So I think this is really a good practice, and also towards, not just towards the data subjects, but also towards the data protection authorities. So recording, documenting everything while you are dealing with personal data. Then once you have, let's say, the outcome of this test, then you should integrate that into your plan, into your data processing plan. So you should really use those results and keep those in mind when you are processing personal data. And finally, you should keep under review this test. Now, what do we mean by this? As I mentioned earlier, this test should not be just a one-step thing, but like a continuous living document or a living process. So once you identify certain risks, also during your data management process, if anything changes, you should, you know, adapt to that and possibly change your practice accordingly. Now, a few words about step one. So as I mentioned, the first is to decide before you do anything, before you start collecting personal data. The first step is about deciding whether you need to do this test at all. Of course, it is very useful if you have a data protection officer in place, and you should then consult with him or her. Also, of course, the next step is that you should check in the GDPR which are those cases where it's an obligation to have it. And if your data processing does not fall under these categories, then you should assess whether there are any other factors based on which it should be advisable still to have this test. And as I mentioned, you should document finally your decision. For example, if you decide not to do a DPIA, in that case it is extremely important to document and have it in your records those arguments why you at the end of the day decided not to do this test. Basically, it's, you know, it's a protection for us, you know, through these arguments why we basically decided not to do this test. And of course, as a final remark here on this slide, if you are in any doubt, then it's always better to do the DPIA. Now, the second step in more details, so once we have identified whether we need to do a DPIA, the next step is to describe our data processing in general, and also in more details. What do we mean by describing our data processing? Is basically looking at these four main aspects of the procedure. So looking at the nature of the processing, of the scope, of the context, and also of the purposing of the processing. Here you can find a few examples. I would not go into details of this, just to give you a few ideas. So when you would like to describe the data processing that you are doing with those personal data, when you are addressing the nature, then you should give details about how you collect the data, how you store, how you use, who will have access, and all these things. Then you should also describe the scope of the processing. So what is the nature of the personal data? So what are those personal data exactly that you will be processing? What is the volume, whether they are sensitive data, and so on. Furthermore, you should also address the context, which means that you should specifically say and record what is the source of the data, so from where you obtain that data. Also, let's say the relationships individuals will have later on with their personal data, whether they will be able to control their personal data, to control what will happen to their personal data. Also, if there are some vulnerable groups affected by data processing and so on. And finally, one of the most important aspects that you will need to describe is the purpose of the processing. So, what is the reason why you need that personal data? What are the legitimate interests of yours behind? Also, what is the intended outcome of this processing? And also, what will be the benefits of processing? So, what will be expected after this procedure is completed? Yeah, sorry, maybe I did not switch to this slide. So basically this is about the purpose and the context that I've just explained. Now, as a third step, I mentioned that when you start this DPIA process, you should, as a best practice, consult some individuals. Now, who should be these individuals? Of course, the data subject. It is really good practice to consult with them when you are, or before you are starting to process their personal data. And again, it's very important that when you are consulting with these individuals, you should always record what you discussed, especially if, let's say, you had a consultation with the data subject, and the outcome of that consultation is that you make a decision which is different than maybe the what you have been discussing with the data subjects. And why? Because you might have some other interest which can be, let's say, higher or more significant, so to still collect specific personal data. But in this case, if there is this difference, then it's very advisable again to record so that you have it in your files. And let's say, this is another question, who else should you consult when you are doing this test and trying to assess the potential risks of data processing? If you are working with a data processor, then of course you should also involve the data processor, the internal stakeholders who may have access to this personal data. Of course, you should also ask the legal, the IT experts. Some ethical aspects may also be considered. And at the end of the day, when you do this test, and let's say the outcome of this test is that your processing of specific personal data is likely to result in a high risk on the rights and freedoms of data subjects. So if the outcome is that there is high risk, then before you start doing anything, you should consult your own data protection authority. So this is also, let's say, a requirement under the GDPR. The next question is through this cycle. So when we start to do the DPIA, is to assess the necessity and proportionality of collecting personal data. So we need to assess whether collecting of such data is absolutely necessary for our purpose, for our project, and how proportionate is that. So whether we are collecting excess data or whether we are able to collect only those data which is specifically required for us. And let's say if you would like to assess so necessity and proportionality, there are some questions you may ask from yourself. So whether the plan that you have with those personal data really helps, whether that plan really helps you to achieve that purpose. Because you should, really only collect those personal data, and only if it really helps you to achieve that purpose, if it's really helpful for your research. Also, there is another question that you may ask, whether there are other potential ways to use, so other than collecting those specific personal data, which may cause less harm to an individual. And if yes, if you are able to find another way, then you should of course resort to that instead of collecting to personal data. And now this is the next step to which there is a table that I've been mentioning to you. So how can we identify the risks? So once we have, started this process, we have consulted with the data subject and so on, we need to assess the risk, so the level of the specific risks. And now how do we do that? I think these two tables may be quite helpful. So when you would like to assess the risk, you should basically look at two very important aspects. The one is how severe an impact may have your collection of personal data on the rights of the data subjects, and how likely a harm is to occur when you are collecting this personal data. And if you compare those, then you can come to a conclusion whether what you are doing with personal data will result in a high risk or in a low risk. So for example, if the impact you may cause by collecting personal data and processing personal data, if the impact on the data subject's right is, let's say, minimal, but the likelihood of harm is let's say, is also remote, so it is not very likely that it will happen, then we can talk about a low risk and so on. So you can see it on the table. And in the next table, it just, I don't know if you can see it, it's just about, how you can, again, assess the risk, let's say how high is that or low, and you can use this also when you are preparing your DPIA test, so as an outcome, so to record what the outcome was about the risk. Then the next step, so once you have assessed the risk, so whether that is a high risk or low risk, the next step is to see that, let's say we have some high risks during this process, then what can you do in order either to eliminate the risks, or if you cannot eliminate them, at least to mitigate them. And then here on the slide, you can read some examples, what you can do to mitigate specific risks. For example, of course, the the simplest way is to decide not to collect those data, which may result in high risk, so not to collect them at all. Or you can reduce the scope of the processing, or reduce the retention period, so to delete the data earlier, so only to keep specific data for a shorter time, and so on. You can find some examples there. Now, finally, how do you conclude this test? So, what happens next? So once you have assessed the risk, so first you had a consultation with the data subject, internal stakeholders, you have assessed the risk, came to a conclusion whether there is a high risk, low risk. After that, you have also looked which risks remain, how you can also get rid of certain risks, how you can mitigate some risks. Now, what do you do then next? Excuse me. So how do you conclude your DPA? Again, I would like to emphasize, as always, record. So always record your findings, so your arguments, so what conclusions you have drawn from this test. So also, when you are preparing this, let's say, closure or this summary of the test, you should address these questions, like what additional measures you plan to take regarding the personal data, whether risk has been eliminated, reduced, and finally, as a conclusion, whether you need to consult the data protection authorities. As I mentioned, this requirement to consult with the data protection authority comes when you came to a conclusion that your data processing may result in a high risk on the individual freedoms of data subjects. Also here in this slide you have this remark that even if you find during your assessment that this process may result in high risk, you should not always decide to eliminate those risks, because there might be some other benefits compared to that. And it's absolutely fine. So even if there are some risks and you still decide to continue with collecting and processing personal data, that's fine. You can go and do that. But always just keep in mind to record everything in writing. For example, your arguments why you decided to go on with processing personal data despite specific risks that have been realized. And then finally, what happens next? So after this test, once you came to a conclusion of a test, then you should integrate that into your project plans. Now, what do I mean by integrating this? I mean the outcome is always to keep in mind, as I emphasized this so many times, during the entire process. So always keep in mind that what you are doing with personal data can have impact on data subjects. What are those impacts? Also, if you decide to change anything during the process, then also to record this and so on. I think what is also very important when we are talking about good practice is to publish. So to make it public, your DPIA, your findings, the outcome of this test. And why? Because I think it is very good to show transparency, again, not just to data subjects and to the data authority, but in general, that your institution really cares about the protection of personal data. And now the third part of my presentation, now moving a bit further from GDPR aspects of research, is about open access and data management. And the reason why I would like to talk about this, because as I mentioned at the beginning, there were questions that I received specifically related to open access and the data management plan. Specifically under Horizon 2020. So I believed it would be helpful to, let's say, also talk about these issues as well. And hopefully you will find answers to those questions. So those who have sent those answers, those questions, hopefully will find answers in these slides. If not, then at the end, we will have some time to discuss those as well. Now, talking about open access, now what is this open access? So under H 2020, there is a requirement. Basically, this was introduced by the EU related to some specific projects. So this is a requirement to have an open access to scientific publications. This is an obligation, so to ensure open access to publications. And there is also another aspect of this requirement, again under Horizon 2020, is to have open access to research data itself. So not just to publication, but to research data as well. I made a remark here that in some cases open rights are possible. I will explain what that means. But now more specifically, so what is open access? It's basically a requirement of the EU to have an online access to scientific information that is free of charge to the reader, so that more and more people could have access to research data, so, and not only to research data, but also to the outcome of a specific research. So what is research data is basically, when talking about open access, is basically all information which is collected during a specific research project and which can serve as a basis for a specific outcome, reasoning, and so on. And what specifically means giving open access to this kind of research data is basically the right to access. So you have to give an access to as many people as you can or possibly can. So to have access and also to reuse these data that have already been collected for some other purposes. So this is about open access. And now more specifically about this pilot under the Horizon 2020. Which is the Open Research Data Pilot launched by the Commission. And what was the aim of this pilot? Is basically to improve and maximize access to this data, again, as I mentioned, to ensure that more and more people have access to this data and also the possibility to reuse this data later on. The scope of this pilot, of this ORD pilot, earlier, only some specific projects were subject to this requirement. Now it has been extended, and basically all research projects are subject to that. And what is the rationale behind? I have highlighted, I think there, yes, the Commission's approach is that there's this principle that research data should be as open as possible and as closed as necessary. So there is, of course, one approach that we should open access to this research data, but of course in some cases it is understandable that they should not be opened. So in some cases this closeness should also be considered. Okay, you cannot hear me again? Sorry. Okay, so is it better? Probably. Is it? Okay. So, and I mentioned to you this possibility to opt out because the general approach is, so the Commission's general approach is to ensure access to this data, but in some cases there's a possibility to opt out from this requirement or from this obligation. And if that is the case, then you can do that, but before signing the grant agreement. So you have that possibility. But once you decide to opt out, so once you decide that you would not like to grant open access to your research data, you can do that, but then you have to give reasons to that. But just for you to know that there is this possibility. And now, talking about the data management plan and how this is connected to this open access and to this pilot that was introduced by the Commission. In case you decide to participate in this pilot, so if you do not opt out, that basically triggers another obligation, which is to prepare a data management plan. And now, what is this data management plan? Just very briefly, it's basically the description of your data process, so how you are going to manage the research data. And the Commission on its website, they have published this information about what the data management plan should include. Basically, there is also a template which is attached to, let me check if it's in the guidelines or, the template that is recommended by Horizon 2020 is attached to the guidelines. So you can find that there. It's basically a set of questions that you should assess. But there is also another template by the European Research Council, so they are also proposing one. And also Open Science, they also have their own templates. So these are, basically free for you to decide which you will use. They are quite similar as they follow, a similar rationale. Yes, so as I already mentioned, so all projects which are participating in this pilot, unless they opt out, they do have an obligation to have this data management plan, so to prepare this data management plan. There was a question whether the costs associated with preparing the data management plan are also included in the budget, and the answer is yes. So you can find that specifically on the web page of Horizon 2020, also in the guidelines. So that is quite obvious, so that you can calculate those costs. So when you are preparing a data management plan and you have some costs during that process, then those can be included in the budget. Now, there was also another question about submitting the data management plan, whether the data management plan, a full data management plan has to be attached or submitted when you are submitting your proposal. And since, as I mentioned, participating in this ORD pilot is not a requirement because you can decide not to participate. Submitting the complete data management plan is also not an obligation at the very beginning. So basically you have 6 months after you submit your proposal to prepare this data management plan. And here you can find just a few ideas what this application should include. Yes, and basically I think here what's most important is this 6 months requirement, so to submit this data management plan. And then the research data management plan, its life cycle is again not statistic. I mean, in a sense that it's not just enough that you prepare this data management plan, just as, you know, very similarly to the DPIA test. So this is not just a one-step thing, but it should also be continuous. So you need to have continuous updates as you develop your project. So if there are any changes, then it is recommendable that you change and modify your data management plan. And also periodic reporting is also connected to this. So also you can check the Commission's website how this should take place. This is also a requirement. And just further, I already mentioned about the reimbursement of costs. So here you can find specifically where the reimbursement of costs can be found. So it's in the grant agreement in Article 6. So you can always refer to those articles when you have questions about the costs. And as I already mentioned, the template for the data management plan can be found in Annex 1 of the guidelines, and also the ERC data management plan template, you can also find that as well, and Open Science, that is, let's say, the third one that you can refer to. Just a few words about the Horizon 2020 template specifically. Here the most important concept is about fair data management. So this is basically the reason why data management is so important, so that you have a data management plan. So the FAIR is an abbreviation that stands for the requirement of, you know, how you should treat and collect research data, and or how, you know, the research data should be addressed or they should look like. So they should always be, F stands for findable, they should be accessible, interoperable and reusable. So this is something, this FAIR, so to say, FAIR principle is what the Commission set up as a goal when they decided to grant open access to specific research data, so that these 4 things are ensured through open access. And this is why I'm mentioning this FAIR principle, because the entire template is basically based on this. So when you are filling out this data management template, you should be able to demonstrate that you comply with this, amongst others, with this FAIR principle. And now just a few words about the structure of the template. As I mentioned to you, it is designed to have a set of questions. So when you open this template, there will be a lot of questions that can guide you through. And by answering those questions, you can demonstrate how your data management takes place within your institution or during your research. And as I pointed out so many times, this is a living document, so it needs updates all the time. So it's once you submit it with your proposal, later on during your project, you will need to update it. That's why it's very important that when you are preparing your data management plan, you always include a version number and also a timetable, specific timetable for updates, so that one can easily find, you know, the changes that you did to your data management plan. And now finally, maybe if you will have some questions in this aspect, then we can discuss that in the end. I think I will finish earlier. So finally, what I would like to share with you is CEU's best practice. This is a different topic now, just I thought it might be of interest to you, specifically after all these boring slides that I went through at the beginning. So just to share with you what we did at Central European University in order to implement the GDPR. I only have this one slide and trying to summarize everything that we did. So at the beginning, probably I will tell you how we started this whole thing. So it was more than, let's say, 2 years ago that we started the implementation. We set up a specific team without university. We called it a force task or a GDPR project team. And this project team involved and still involves, because this is a continuous work. So, you know, implementing and complying with GDPR is a continuous work. And this project team is made up of several people. We have representatives of IT, legal, also representatives of different departments and units. So this was the first step, to set up this team. And then we decided that as a very first step, we should just, you know, send out a very simple survey to all our colleagues. That was really a simple survey, just to see where we stand. Whether people in our university are at all aware that they are dealing with personal data, what kind of personal data processes we have, what is happening with personal data, and so on. And it was very interesting, just to give you an example, that one outcome of this survey was that, you know, when we just asked this very simple question about our colleagues, whether they consider that they are dealing with personal data, there were some units who answered, no, they never process personal data. So can you imagine? So this is from where we started. And then we continued. We have, of course, then we continued with workshops as a next step. So we called people together. We gave them first very basic trainings about the basic principles of GDPR, what it is all about, what will be the new rules. And also during these workshops, we had another survey, which was a more in-depth questionnaire. We also had an external advisory firm who was helping us with these workshops. We went through this survey together at the workshop, and the aim was to find out basically two main things. The one is, what kind of personal data do we have within our institution? So what kind of personal data do we collect and manage on a daily basis? And the second thing was to map the data processes within the institution. So what is happening to those personal data that we are collecting? And basically this is what we call an awareness campaign through this workshop as a let's say a second step. And we also had, you know, some other things done. For example, you know, we had all those colorful posters all around university, you know, just drawing attention of the people that GDPR is coming. Make sure that you keep, you know, personal data confidential. If you have any questions, always consult us, and so on. You know, so this is where we started. And the outcome, let's say the first outcome of this first phase was that we drew up a data inventory. So as a result, we were able to see what kind of personal data do we have within our institution, where it is stored. So this was the so-called data map that we drew. And the second big, let's say, outcome was the data process map. So it's not just about the data, but also the processes that we have within our institution. That was a very good starting point for us to have these two inventories, so that we can, after that, assess where we stand with data protection, and especially with the requirements of the GDPR. So then we made a so-called gap analysis, and we assessed two main things. The one is about privacy, the other was about security. So we also looked at the IT aspects, so whether we have all the IT tools in place that can help us actually secure the privacy of personal data. And once this gap analysis was put together, that was a very good guidance for us to say where we have gaps, so what needs to be improved within the university. And after that, based on those results, we were able to draw a plan for implementation, which was basically a plan of a lot of to-dos, really looking at the different processes within our institution, the different practices, and not just this, but also to look at and really analyze in details our internal documents. So starting with updating our data protection policy, drafting or updating our privacy notices, consent forms. So all these documents have been reviewed, updated, so that we have at least the formal basis in place. And now, after this, once we set up the basics for a proper personal data management within our institution, everybody was kind of, trying to feel relief that, wow, now, we have everything in place. And that was the point when we, told everyone that, this is just the beginning. So once we have set up the basics, now the real work starts, because once you create an environment within your institution to ensure the privacy of personal data, what is most important is that after that, you really keep that safe environment continuously, because that is basically the essence of the whole thing. So now what we are doing, once we have set up the basics of data protection within our institution, we are continuing with trainings. We also had an online training as well. And in addition to that very general training at the beginning that I mentioned, we already have some specific trainings with specific units, because, for example, the HRO, the finance, they all have, different practices. So their approach to personal data should be different. So we started those specific trainings, and we will continue with those specific trainings in the future. Our team is still together. I'm in this GDPR team. We will keep continuing this work. We also have external support. We have an internal data protection officer. We also have a lawyer now within our team who is dedicated to data protection issues. And we are sometimes also consulting with an external professional if there are any questions that maybe we cannot answer. So, in very brief, this is what I wanted to talk about to you today. Thank you very much for listening. I hope you are not that much tired. I think we have pretty much time, so, or I don't know what your plans are, and we can address some questions, or... Yes? Maybe, yeah, that was her.
I have a question in terms of resources.
Yes?
How many people were involved, or how many person-months did you invest in this?
Here, basically the entire institution, and I'm not exaggerating. This project team, if you are interested in that, it was about 10 people, because we really wanted to keep this group small, in a sense that we could still be able to work together, but on the other hand big enough to address the different needs or aspects, so IT, legal, HR, finance, all these things. But when you set up a group, you also have to keep in mind that those people need to be able to work together so that it's not too big. But thinking about on a larger scale, our entire institution was involved. So what I did not mention, we also had, as a part of this process, we had separate interviews. So, personal meetings with the representatives of the different units. So each and every unit and department was contacted separately, and we sat together, we had questions about what they are doing with personal data, what are their processes, and so on. So this is basically the entire institution.
And if I may, follow-up question was, if you make a survey, how can you assure that, for example, PhD students who do collect personal data respond to the survey for their professors?
Yeah.
So
yeah, I know. This is something that we are very much aware. In this first part, in this survey, we did not involve the faculty and the researchers, so that will now come from autumn. This only involved the administrative staff, because as to research specifically, we will have specific trainings in this academic year that we have just started. So that will be separate, yes. And I hope that they will be as enthusiastic as as the admin staff was, hopefully. So, yeah, and you had a question, probably?
I just wanted to ask, is it expected to do the DPIA
Okay, so the requirement to do the DPIA does not depend on the type of the project, but it depends on the type of data processing. So basically, if you remember, there were those 4 cases that I listed, in which cases there is an obligation. So it depends on what you intend to do with the personal data. So what is your personal data management process? So what are the effects? So I would approach it from that aspect. So in general, yes, in case of all projects, if they are dealing with those specific things. So if there is, let's say, profiling on a large scale and so on. Maybe a more general answer, when you are talking about a project, some don't really like when I'm saying, that when in doubt, just do a DPIA, because it's not that easy, I know, because it's just an additional administrative burden. But really, if you would like to show good practice, I think it is always advisable to do the DPIA, irrespective of what the project is about. Of course, if it includes personal data, then if you do the DPIA, you can just never make a mistake for good practice. Yes? I'm sorry. Sorry, actually, can
the DPI, who actually assesses whether it's high risk or not? Is it
sorry, I somehow cannot help you. So hear you? Sorry, the DPIA.
Okay, the DPI has to be done.
Yes.
Who makes the assessment whether it's high risk or not? Is it
the
person who's doing it, or is it the commission?
Yeah, I know this is let's say a constant debate also within our institution, because basically just everybody just tries to avoid it because it's really additional administrative task. The way we are usually doing it is that the researchers do that as a first step, because they know what they are what their purpose is or what they are going to do with the personal data. So we always ask them to do this test, and then the DPO is always involved, so they can consult the DPO, the legal, and so on. So basically, this is a teamwork, and at the end, it is the DPO who signs and says that, okay, this test is fine or it has been done. The reason why I'm explaining this is because within our institution, we have as most of you, I guess, have an ethical research committee. And this ethical research committee decides on a specific project, whether that can be accepted or not. And as part of the assessment of this committee, we introduced the data protection assessment. So this is a separate process. So basically, when a researcher submits a proposal to the ethical committee, they are also required to assess their project, to describe their project from data protection aspects. We do have ethical research policy, and there we have an annex which lists, all those requirements that a certain proposal has to meet. And one requirement, a separate requirement, is about data privacy. And part of that data privacy, basically, it's a checklist of, you know, the steps that the researcher has to do and to prove that, you know, they have really considered the data protection aspects. And specifically, one point there is the DPIA. So whether a DPIA has been made, yes or no. If no, then, you know, give arguments. If yes, then just, you know, submit, and so on. So that is how we do it. But as a first step, it's always the researcher consulting with the DPO and the legal. So basically, that's group work. Yes, but I think there is no specific rule to that, so you just have to agree within your institution who will do that. And I think, you know, when you are doing that, since the liability regarding data protection is always on the institution, so, you know, it is the institution or the management who can decide, you know, how to deal with this task. Yes?
I have a question regarding the DPIA
Mm-hmm.
and the management plan. So you were saying that the DPIA is more related to data processing.
Yes.
And related to a specific project. So I wonder if it's a good idea to have data processing, figured out the kinds of data processing inside the organization, and then you have different DPIAs according to the different data processing. And then, for instance, in the data management plan, you refer to that DPIA. Is this like a good option, or?
Yes, I mean, maybe I would just comment on the first part of your question when you said that DPIAs, so this test relates to processes rather than projects. I think these are not separated because, yes, you are absolutely correct that the DPIA relates to a specific process, right? So when you are processing personal data, then you should have this test. But these processes are always or can be part, right? The data processing can be part of a project. Yeah. So these two should not be separated. So if there's data processing then within a project, then of course you should do a DPIA.
Yeah.
And
I was thinking on patient registry, for instance.
yes.
So building up the patient registry, then you have to have a DPIA.
Yes.
And if this is part of a project,
Yes.
then I was wondering if I should establish a new DPIA for that project or refer to a standard DPIA that I have in my organization for registries.
Yeah, I think it depends because as I mentioned in one of my slides, there are some exceptions, right? When we do not need to do a DPIA, and what exemption is if you have already did earlier a DPIA under the same circumstances. So I would say that, let's say if there was a project earlier where you did a DPIA, and then there is, or if it's not a project but simply a data processing, and then later on there is another process which is absolutely similar. I would really like to point out that it's absolutely similar, so the same circumstances. Once you did a DPIA, I think you could use that DPIA for this other one. But really, you know, I think we should be careful that, you know, just to use that same DPIA if the circumstances are all the same. But in that case, yes, I think you can use that.
For the European Commission, you have to file the DPIA in the project management plan, or I did not get the
I'm not sure about the DPIA, where it should be, you know, placed. But I mean, the only thing I know is that when there are these proposals, you know, under Horizon 2020, they always require, or I mean, in most of the cases, I experience this requirement to submit a DPIA. But whether it's within the data management plan or separately, I'm not sure about that. But this is just a guess, and please do not take this granted. I can imagine it's separate in a sense because, you know, one is basically the nature of the two are a bit different, although very closely related, because the DPI is a test on potential risks, while the data management plan deals with, you know, how you are going to manage the data in the future. So somehow very closely related, but also a bit separate. But I think the best would be to consult, of course, directly with the Commission to see what their requirements are. So. Yes?
I have a question with regard to GDPR.
Okay, just to make it clear, so you are working with third-party countries. I mean, the reason why I'm asking, sorry? Okay, you know, the applicability of the GDPR depends on where personal data is being processed, so the place where it is being processed. So even if you are, so if personal data is processed in an EU country, then it applies, I mean the GDPR applies. If, let's say, we are talking about a third country, I'm now not talking about transfers, of course, but if, let's say, some data is collected, managed, everything stays in the US, then it's out of the scope of the GDPR. If there is transfer, or let's say there's a US company who is doing business in Europe, and they let's say, transfer from there to Europe, and, you know, data protection takes place in Europe, then the GDPR will be applicable. So, yeah. Yes, but more specifically, if you could. So basically, you are collecting data from third countries. Is that correct? Yes, but you are processing it here in the EU. Absolutely. I mean, yes. The answer is yes. Okay. Some other questions? Yes. Yes.
Just a question about consortium agreements for 2020. So we have the DESCA agreement, which covers the obligations between the parties as we know them.
Yes.
However, in the new GDPR, nothing has changed, but everything has changed.
Yeah.
Is there a case for dedicated templates for data processing or data transfer agreements between the participants?
I've not come across such templates. What I can tell you about is our practice, because we are also consortium members, and basically we have our own templates that we have put together for data processing, because consortium members, as we all know, can be data processors and data managers at the same time, you know, depending on what the relationship is. So we developed our own template and attached that, I mean, to the agreement, but I'm not aware of some.
Yeah, that's exactly the point. We all borrow, we all trying to develop templates and trying to develop data transfer agreements. But that's why the DESCA model is so, to date, has been so welcomed, and people know the DESCA model when it comes across their desk. Is there a case, I just might agree what I'm saying, it's a bigger question really, that the DESCA model should encompass 2 or 3 different types of data transfer agreements that would mean that everybody would be familiar with them, and so it wouldn't take as long to negotiate and conclude these agreements when they come across your desk. It's just a figure, I don't expect you to answer, but you know, if this group says, you know, this is what should be done and would help us in our work, maybe it's something we can take from it. Probably that could be a good idea, because I assume, I mean, talking about my own experience, we are all, you know, just trying to follow what's in the GDPR, because there is, you know, really very clear guidance on the content. We all know that, but still, of course, you know, I think it would be very helpful if there could be some kind of cooperation or working together. Yes. Okay. And thank you very much for your attention. Yeah.